Travis Wayne Goodsell. I'm currently working on the objection and thought I'd give you guys an update on how it's going and what I've found. Judge Oberg had listed 28 USC 636 B1 for her justification for filing the report and recommendation to have my case dismissed with prejudice. And so looking that up, I found 28 USC 636 B1A, which says a judge of the court may reconsider any partial or pretrial matter under this subparagraph A, where it has been shown that the magistrate judge's order is clearly erroneous or contrary to law. So, yeah, I can do just that. That's my objection. And as I have told you before, I'm going to have 4 categories that lead into each other. One is bias for the defense. I found that code 28 USC 455. And go over it with you, because this does have major impact in this case against the corporation of the President of the Church of Jesus Christ of Latter-day Saints, and will apply to District Judge Clark Waddups. A. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. I cannot have a fair trial, so I may screw myself by pointing this out, but we shall proceed anyway. B. He, and I notice that it's a masculine or male-dominated wording here in the law, but nonetheless, he shall disqualify himself in the following circumstances. So this is what they've got to do on their own. 1. Where he has a personal bias or prejudice concerning a party, a personal knowledge of disputed evidentiary facts concerning the proceeding. Yes, all Mormon judges are in this position. All Mormon judges must disqualify themselves from handling a case involving the church. It's not complicated. It's in federal law. 2. Where in private practice he served as a lawyer in a matter in controversy. Oh, I might be able to use this against Judge Oberg, because she was hired because she served as a lawyer in the federal court here in Utah. And I can show her history. Oh, this could be interesting. Or a lawyer with whom she previously practiced law. So no, Judge Waddups, I didn't see him involved in her previous cases, but I may need to check. Or the judge as such lawyer has been material witness concerning it. I don't know if she's Mormon, but she does refer to the church rather than the corporation. And that shows a personal bias or prejudice concerning a party that I might reasonably question, as I pointed out yesterday when I read it. 3, where he has served in governmental employment, in such capacity, participated as counsel, advisor, or material witness concerning the proceeding, or expressed an opinion concerning the merits of because that expressing an opinion is what she did as the defense counsel in other practices of controversy that might reasonably put her in question. So yeah, we're checking this out. 4, he knows that he, individually or as a fiduciary, or his spouse or minor child residing in his household, has a financial interest in the subject matter in controversy, or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. Her job as a magistrate judge. And if she is a Mormon, which Clark Waddups is, his interest is substantially affected by the outcome of my proceeding. This is why Mormons cannot protect the church. You just can't do it. If you go into law so that you think you can protect and defend the church, you can't do it. You're automatically excluded by the law itself. 5th, third degree relationship. So any third degree relationships to spouse or a person within third degree. Yeah, she does. She lives in Utah. There is definitely a third degree, second degree, and potentially first degree relationship to a Mormon. So, like I said, I may be shooting myself in the foot here. There may not be an impartial judge in the federal court of Utah. I don't know what I'm supposed to do after that. If there is no judge who can hear the case, what happens? I guess it goes to the appellate court. I did find out, though, that in the magistrate judge situation, that I can appeal this all the way up to the United States Supreme Court. So that may be where it ends up. But that may be years down the line. Dear God, I cannot survive that long. A judge should inform himself about his personnel and fiduciary financial interests. Yes, Clark Waddups, please tell us about your financial interests with the church as you've been paying tithing and any other donations such as fast offerings or to the Book of Mormon Fund or the Missionary Fund or the Temple Fund or and make a reasonable effort to inform himself about the personal financial interests of his spouse and minor children residing in his household. Guess what, Clark Waddups? You've got to expose all your family's financial investments in the church and financial interests in the church. For the purposes of this section, the following words or phrases have the meaning indicated. Fiduciary includes relationships as executor, administrator, trustee, and guardian. Is the church an executor of Mormons? An administrator of Mormons? think so. Because they, yeah. Ooh. Wow. Let's check this. On this date, definition, a person or institution appointed by a testator to carry out the terms of their will, a person who produces something or puts something into effect. Executor is someone who is responsible for executing or following through on an assigned task or duty. Yeah, I think that qualifies because you pay tithing for the purpose of the corporation, for the buildings, Book of Mormon publishing, and such like that. I think, wow, administrator. Person responsible for running a business organization. Yeah. The church is all Mormons' administrator. Thus, no federal judge can be a Mormon and have the Mormons or the church be involved in either party. So Clark Waddups is going to be forced to confess this, and it's going to have to be reassigned to somebody who's not Mormon. Damn. I may never get to have justice. Wow. What do I do? Financial interest means ownership of a legal or equitable interest, however small, or a relationship as director, advisor, or other active participant in the affairs of a party, such as a Mormon, an office in an educational, religious, charitable, fraternal, or civic organization is not a financial interest in securities held by the organization. Okay, wait a minute. They may be given a loophole here. An office, let's see, except that, so financial interest. An office in an education, in a religious organization is not a financial interest in securities held by the organization. Oh. So religious is not a financial interest. The church is different from all other religions. All other religions make it a donation. Tithing is not a donation, it is mandatory. And then the temple, okay, so I have to argue it in court, in a trial first, before I can claim that the church's tithing is indeed a financial interest as the corporation, not the religion. Okay, but I can do the temple covenant where Mormons swear to kill themselves before 1991, as Clark Waddups did, to support and sustain the church over the United States of America. So ownership in a mutual note doesn't fit, so it's not a financial interest. But it shows a connection, as he is a member, and the outcome of the proceeding affects his membership status. The church can excommunicate him if he decides to judge against the church. Of course, the church would be disincorporated, so they can't really touch him, but okay, so I can't use that. That was supposed to be my argument in the case, though. No justice, judge, or magistrate judge, this is E, shall accept from the parties to the proceeding a waiver of any ground for disqualification enumerated in subsection B, where the ground for disqualification arises only under subsection A. Provided it is preceded by a full disclosure on the record of the basis for disqualification. Waiver may be accepted provided it is preceded by a full disclosure on the record of the basis for disqualification. Okay, so we could waive the conflict but yeah, see, no, I don't want to waive it. Okay, notwithstanding the preceding provisions of this section, if any justice, judge, or magistrate judge, bankruptcy judge, to whom a matter has been assigned would be disqualified after substantial judicial time has been devoted to the matter because of the appearance or discovery after the matter was assigned to him or her that he or she individually or as a fiduciary, or his or her spouse, minor child residing in the residence or household, financial interest in the party other than an interest that could especially affect the outcome, other than an interest that could be substantially affected by the outcome. Disqualification is not required if the justice, judge, magistrate, etc., as the case may be, divests themselves or herself, now they put herself, of the interest that provides the grounds for the disqualification, which is the final outcome. So yeah, this is just the first stage, and so then the next one would be listing violations of the Constitution, petitioning for a right to redress grievances, going over the docket, showing how I'm being denied, and how the rules show that the defense filed 24 days late, and that the judge or the clerks shall enter it on the docket. They have not. And that the judge shall side and recommend, she was supposed to recommend to the Clark Waddups that I be granted. There's one thing that they were trying to claim, the request for relief. I found in her referral to the law that she's not even allowed to do that, and yet she did it. So I can point that out as well. And then co-conspirator, by showing the bias, by showing the violation of the Constitution and the laws of the United States and the rules of the court processes and procedure, she then now, her bias is now a co-conspiracy. and I can show the co-conspiracy laws, and then go right to treason, because she is going against the United States interests. She becomes an enemy of the people. As Clark Waddups, if he does not step down or make a judgment that shows that he is not biased towards the defendant, for which the defense is going to be very upset. Hey! So, can it be reverse bias? I am judging for the plaintiff because I'm biased towards the defense. So it's already 1 o'clock, so this may not get done until tomorrow. I'll do a full reading when I do finish it. I may do a video if I find something more to add, so stay tuned.